Welcome to this term's talk for the Inner Temple History Society. My name is Donald Cryan, and I'm the chairman of the Society. I'll be moderating the questions and answers this evening at the end of the talk. Those online, I would ask to send in their questions in the usual chat room way. This is the first time that we've had the great advantage of holding one of these talks in our brand new lecture theatre. And I'm absolutely delighted that we are here to be able to use all the facilities that this theatre now offers to us. The world has changed since the pandemic, and we now have an international audience with over 200 people registered for this evening. And we're particularly fortunate to have one of our own benches talking to us tonight, and that is Sir Michael Tugendhat. Sir Michael is an honorary professor at the University of Leicester and a fellow of the Institute of Advanced Legal Studies. But we know him better in this inn as one of the stellar advocates of his generation, appearing for such famous clients as Posh and Becks, Michael Douglas, and Catherine Zeta-Jones in cases involving the media. But he also represented the press and other branches of the media in their efforts to maintain the benefits of free speech. He had an equally stellar career on the bench, to which he was promoted in 2003. But since then, and since his retirement from the bench, he has not in any sense been idle. In 2016, he produced a scholarly and indeed highly readable book, Liberty Intact, Human Rights in English Law, and now jointly with Elizabeth de Montlaur Martin, he has produced a book in French, The Rights of Mankind, Liberty in France and England, 1159 to 1793, which has been published in French by the Société de Législation Comparée in Paris, and it has been awarded an academic prize by the Academy of Science and Politics in France, which is quite an accolade, to say the least, for one of our benches. It's an extensive work, and Sir Michael is hoping that we will shortly, or eventually, be published in this country in English for the likes of me to read it. But he has very kindly allowed me to see 2 chapters, one of which he both of which rather he's reduced to a translation for me. And from that I know that it is equally scholarly and equally interesting to his earlier work. This evening he has chosen to concentrate on the intriguing subject of the social and jurisprudential context of the disappearance of slavery from northern France and England from the 13th century, and how that thinking evolved and reverberated down the centuries thereafter. It is clearly the most fascinating topic. It's not for me to say more than we welcome Michael. I look forward very much to hearing what he has to tell us. Michael.
Thank you, Donald, for that very generous introduction. Welcome to the Inner Temple. Not only do I say that to those of you who are present here tonight, but also to the many people who are present online. I'm very proud to be the first person to give a lecture of this kind in this very beautiful new building, which was opened in May of this year. The purpose of the new floor here is to enable the Inn to continue the work for which it was founded as long ago as the 14th century, and that is for the giving of lectures on the law. In this lecture today, we shall cover many of the centuries during which lectures have been given in this inn. The theme of this lecture today is the influence that French and English-speaking lawyers and philosophers have had upon one another from the invention of the English common law in the 12th century to the 18th century and beyond. For the purposes of this talk, I shall discuss the right to liberty in just one of its many aspects, that is, the prohibition of slavery, which came to be recognized, of course, as a human right. We will see how the abolition of slavery in the 19th century, with which we are all familiar, had as its foundation less known developments in England and France some 600 years earlier. And we will also see how those French and English-speaking lawyers and thinkers passed the baton between each other, keeping alive the ideas and principles during the intervening period. In most parts of the world until the 19th century, enslavement was generally legal in the sense that it was in accordance with contemporary national laws, whether customary laws or the enactments of legislatures. Between the 11th and 13th centuries, in parts of Northwest Europe, slavery was replaced first by less oppressive forms of unfree labor, and then by consensual forms of labor. In France and England after the 12th century, the status or institution of slavery permanently ceased to be recognized by law. It is sometimes said that slavery was then delegalized. This did not happen outside Northwest Europe until the 19th century. Before going any further, it's necessary to consider what is meant by the word slave and related terms. This is because there is often confusion between slavery as a status recognized by law and slavery as a condition in which people are held illegally. Slavery is also confused with other forms of forced labor. When sentencing a person convicted of an offense, a court may order them to perform works. This is not slavery within the definition which is now internationally agreed. Similarly, compulsory military service and other forms of obligatory service for the public benefit are not slavery within the internationally agreed definition today. Since the Slavery Convention was agreed in 1926, the word slavery has meant, and I quote, the status or condition of a person over whom any or all of the powers attaching to the right of ownership are exercised, close quote. In that definition of slavery, the word status refers to a legally recognized status. Since 1926, slavery in that sense has been abolished in most parts of the world. The word condition in the 1926 definition refers to matters of fact. A person may be held in slavery illegally. Sadly, there are large numbers of illegally enslaved people today, including in the UK, as indeed there have been in every century since the legal status disappeared. The difference between slavery and other forms of forced labor is made clear in other legal texts. So the 13th Amendment, which abolished slavery in the United States in 1865, and modern human rights treaties, such as the European Convention on Human Rights, all make clear that certain forms of compulsory work are excluded from the prohibition of slavery and forced labor. A harsh sentence of penal servitude may be cruel or degrading if imposed by a court. If so, it may be unlawful because it's cruel and degrading, but it's not within the prohibition of slavery. International humanitarian law, the the Geneva Conventions, also permits prisoners of war to be forced to work, provided certain conditions are complied with. When we think of the enslavement of human beings that has been practiced throughout the world from time immemorial, we may have in mind men engaged in heavy work in unsafe conditions, such as in the mines of ancient Greece and Rome, and the sugar and cotton plantations of the Americas in the 16th to 19th centuries. But most enslaved people were required to provide domestic, including sexual services, and most of these people were, and still are, women and girls. In France and England, after the legal status of slavery had disappeared, there remained other forms of forced labor. Serfs and villeins were tied to the land they worked. Other forced laborers also included men in England who were pressed to serve on ships, and in France, people required to maintain public works, such as roads and bridges. An important difference between people who were enslaved and other forced workers is that enslaved people were normally taken away from their homelands and all their family and all their social networks. They were completely socially isolated and still are. Now let us start in a time and place which are frequently discussed, but which we don't often associate with legally established slavery, England at the time of the Norman Conquest. The Domesday Book was prepared in the period 1066 to 1087. It reveals that enslaved people constituted at least 20% of the overall population of the Kingdom of England in 1066. It was during the reigns of the French-speaking Plantagenet and Angevin kings that slavery disappeared. From the 11th century, in wars fought in France and England, victorious armies did not enslave those whom they defeated, nor did they raid each other for slaves, nor enslave debtors who could not pay their debts. There are many theories as to why slavery disappeared as a legal status from France and England. These include economic and other non-legal explanations. In this lecture, I shall discuss only the legal explanations, and I shall also confine myself mainly to French and English writers. There were, of course, anti-slavery texts in other countries, which I do not mention. There had been critics of slavery as early as the 1st century AD among both Stoics and Christians. The Roman Stoic Seneca argued that slaves should be treated well. St. Paul and other Christians taught that enslaved people were equal to free people and that the enslaved should be treated well too. But those writings did not lead to the abolition of legal slavery. This theme was taken up again by one of the most influential writers of the 12th century, the secretary to Thomas Becket, Archbishop of Canterbury. In 1159, John of Salisbury, who lived approximately from 1116 to 1180, argued that slaves should be well treated. John of Salisbury, as his name indicates, was born in England, but he was educated in Paris, which was then the most important center of learning north of the Alps. He and Becket, like the Plantagenet kings, were part of a French-speaking culture which extended far beyond the borders of what was then the Kingdom of France. John's major work was called Polycraticus, which he dedicated to Becket, and you see on the screen a beautiful page of the copy, which is thought to have been the copy which John of Salisbury gave to Thomas Becket. This is the first complete work on political theory written in the Middle Ages. Polycraticus foreshadows some of the ideas expressed 55 years after it was written in Magna Carta in its first version, 1215, including the principle that the king must govern for the common good and according to law. John of Salisbury's work was still being read 400 years later. In the 16th century, it became one of the first works to be printed following the importation of the technology of printing into Europe. John of Salisbury encouraged the treatment of slaves as equals. He deduced from what he believed to be the descent of all people from Adam and Eve, that everyone should be judged equally on the basis of their personal virtues and vices. Addressing slaveholders, John wrote, and I quote, "The whole race of men upon the earth arose from the same origin. They are slaves, it is said. Nay, they are men. Remember that fortune has equal power over you. You may yet see him a free man. He may see you a slave. Let your slaves cherish rather than fear you, for what is cherished is loved, nor can love be mingled with fear." End of quotation. Becket famously quarrelled with Henry II, who ruled England and much of France from 1154 to 1189. After the murder of Becket in Canterbury Cathedral, John went to France and later became Bishop of Chartres, where he died in 1180. About 25 years later, new stained glass was installed in Chartres Cathedral, the magnificent glass that we see today. And here you see on your screen the image of Adam and Eve at the top of the window dedicated to the Good Samaritan. There are different interpretations of this image of Adam and Eve. Each of the two persons is engaged in work with the tools necessary for the survival of human beings: a distaff for making clothes in the hands of Eve, and a spade for producing food in the hands of Adam. One interpretation is that Adam and Eve were, in John's words, the origin of the whole human race. All human beings are therefore equal. The shoemakers of Chartres commissioned this window. It represents the teaching on equality of their recently deceased Bishop John. But such images are not unique to Chartres. Similar images of Adam and Eve working together with a distaff and a spade respectively survive in stained glass windows, sculptures, manuscripts, and other forms in churches in both France and England, including amongst the earliest in Lincoln Cathedral and at a small country church at East Meon in Sussex. The origin of the common law is attributed to Henry II. The English common law never recognized that the status of slavery was legal. The common law recognized other forms of unfree status, such as villenage and serfdom, but not slavery. Henry II was a French-speaking King of England who was born and died in France. At the time, customary laws were similar in England and France. They were written in French. This explains why most of the vocabulary of the common law is of French origin today, including action, bail, contract, court, defense, jail, judge, jury, nuisance, sentence, verdict, and many others. French-speaking monarchs ruled in England from 1066 until after the deposition of the last Angevin king, Richard II, in 1399. But French was the language spoken by nobles in England well into the 13th century, and it remained the language of law and administration for long afterwards. There was no standard form of French at that time. Many inhabitants of what is now France did not speak French, whether as a first language or sometimes at all. The French spoken in England, in southwest France in the 11th to 14th century, is sometimes referred to as insular French. You see on the screen now France as it was politically in 1180 in the reign of Henry II, with in pink the very large area governed by Henry, and in the bottom Aquitaine and Toulouse. Insular French was not a separate language, nor an inferior or provincial form of French. It is the version of French used in some of the oldest and most famous and important French texts, notably the Song of Roland. The existence of unfree statuses is reflected in contemporary documents. In 1215, Magna Carta did not protect people of unfree status. It includes, and I use the modern English, and I quote, "No free man shall be taken or imprisoned," omitting some words, "but by the lawful judgment of his peers or by the law of the land," close quote, words which all of us know well. Magna Carta was written in Latin, but there is a contemporaneous translation. It's into French, the vernacular. There was no contemporary translation of Magna Carta into English. In 1354, 140 years after Magna Carta, statutes were still being enacted by the king in Parliament. The modern reprint of the English statute, known as Liberty of the Subject, which will come up on your screen in a moment, shows the original French text on the left with an English translation. The 1354 statute, which is highlighted in yellow at the bottom left, in its English version states, "No man of what estate or condition that he be." In other words, the word man is a translation of the French word homme, which includes men and women, and therefore the protection that had been afforded by Magna Carta is now extended to everyone. Meanwhile, in 1315, King Louis X of France, who reigned from 1314 to 1316, issued a decree enabling French serfs on certain crown lands to purchase their freedom. The decree which he issued started with the words, and I quote, "Since, according to the law of nature, each person is born free," close quote. This is an echo of Roman law. The words of these charters foreshadowed the American and French declarations of rights in the 18th century, which include, of course, the same phrase. In the 14th century, chroniclers described the peasants' revolt, which took place in England around 1381. There is a contemporary or near contemporary picture of it. One of the demands of the peasants was for social equality and the end of serfdom. It was summarized in a ditty, which some of you may know, and I quote, "When Adam delved and Eve span, who was then the gentleman?" Close quote. Since Eve spinning does not appear in the Bible, this seems to be a reference to the stained glass and other images of Eve spinning and Adam digging, which I've already referred to. The disappearance of legal slavery in France gave rise to conflicts of laws. The southern neighbors of France included Muslim-ruled territories of Spain and North Africa. They recognized legal slavery. Enslaved persons therefore continued to arrive in France. Some came seeking refuge from these neighboring countries, while others were brought to France by their masters. In 1402, 4 such refugees were freed by the court in Toulouse. The court declared that it was a privilege or law of Toulouse that, and I quote in an English translation, "all slaves became free as soon as they set foot in the town," close quote. This is known as the free soil principle. French and English law both adapted the maxim of Roman law, which in Latin is favor libertatis, or the law favors liberty. This principle was introduced into the English common law from canon law by judges who had trained in the Church's theological faculties. In 1470, a former Chief Justice of England, Sir John Fortescue, wrote a major work of comparative law. In it, he wrote, and I quote, a law is also necessarily adjudged cruel if it increases servitude and diminishes freedom, for which human nature craves. For servitude was introduced by man for vicious purposes, but freedom was instilled into human nature by God. Hence, freedom taken away from man always desires to return, as is always the case with natural liberty when natural liberty is denied. So he who does not favor liberty is to be deemed impious and cruel. In considering these matters, the laws of England favor liberty in every place. Close quote. That's a translation from the original Latin. By the time Fortescue was writing, it might have been thought that slavery would never again be practiced by French and English people. But that's not what happened. Instead, Europeans took over a trade in enslaved Africans that had long existed. Both before and after the 15th century, enslaved Africans were transported from sub-Sahara Africa to the slave markets of the Middle East, sometimes over land and sometimes by sea. But in 1444, enslaved Africans were transported by sea from south of the Sahara to Portugal for the first time. The voyages to America of Christopher Columbus and Amerigo Vespucci followed. Vespucci described in an account published in 1505 how he enslaved indigenous people and sold them in Cadiz in 1498. In the first decade of the 16th century, Europeans imported slaves into Hispaniola, which is modern Dominican Republic and Haiti, first from neighboring Caribbean islands and then from Africa. About the same time as these developments, that is in 1518, Thomas More, who you recognize on the screen, published his fictional description of the island he called Utopia, in which everyone is equal. By that time, there were no legally recognized unfree people in England of any kind. More was responding to the accounts of the voyages of Vespucci. He may also have been influenced by John of Salisbury, whose Polycraticus was published in printed form in France in 1513. As I shall discuss later, in the 18th century, French abolitionists cited More's Utopia in support of their campaign for the abolition of slavery in the French colonies. More wrote Utopia in Latin. In it, he identifies three categories of people as what he refers to by the Latin word servus or servi. The Latin word is often translated, I would say mistranslated, as slave. But it may also mean a servant, a serf, and a serving man. More's first category of servi is prisoners of war captured by the Utopians themselves. The second category of his servi consists of citizens of Utopia who had been sentenced to forced labor as the penalty for a serious criminal offense. It also included some foreigners who had been sentenced to death in their own countries, whom the Utopians rescued from that fate. The third category of people whom More refers to as servi in Utopia are destitute foreigners who voluntarily migrate to Utopia to find work. In today's terminology, they would be economic migrants with work permits or visas. They were free to leave Utopia at any time, and they would be rewarded if they chose to do so. Clearly, this third category are neither slaves, nor in servitude, nor forced laborers by any definition of those terms, ancient or modern. More's first two categories of servi also differ significantly from the people enslaved as hereditary chattels who had existed in Europe in the past and who were beginning to be transported by Europeans to their Caribbean and South American colonies. In Utopia, no one was born into the status of servus. Convicts could, by good behavior, earn lighter work or remission of their sentence. The servi in Utopia were not the property of an individual master, because in Utopia, individuals did not hold any property. Property was held in common. The duties assigned to them were farming, butchery, menial work in the dining halls, hunting, and public works. They may be compared with people sentenced today to mild forms of community service or perhaps penal servitude. What is most significant is not the three categories of servi that More did include in his description of Utopia. It is that these were the only ones that he included. Utopians did not enslave innocent people to carry out heavy work in the fields or to provide sexual services, as was already happening in the Caribbean colonies. They did not import from foreign countries prisoners taken in other people's wars. In his biography of More, Professor Chambers wrote that bondage in Utopia is penal servitude, a humane substitute for the death penalty, which was, of course, practiced very widely in England at the time. More's Utopia is consistent with the 13th Amendment and with modern human rights texts and humanitarian treaties. In the 16th century, in the southwest of France, slaves continued to arrive in small numbers from Spain and North Africa. In 1558, there was a decision of the Parlement, that is, a high court of Toulouse, in which the court stated, again, that a slave becomes free as soon as he sets foot in France. The principle became a maxim of French law. In 1571, the Parlement of Guyenne, sitting in Bordeaux, made an order which released from slavery some North Africans who had been brought to France. The reason given by the court in its judgment was, and I quote it in translation, "France, the mother of liberty, does not allow that there be slaves," close quote. From 1571 onwards, the French courts consistently ruled in favor of enslaved Africans seeking their freedom. Such cases were more frequent in the late 17th century, when slavery became widely practiced by Europeans in the New World. French courts also used the maxim of Roman law, favor libertatis, the law favors liberty, as a rule of interpretation of written instruments, in particular the contracts that masters made or attempted to make with former slaves. Jean Bodin was a French lawyer who lived between about 1530 and 1596. He was also a lawyer and a politician, and the author of one of the major 16th century works on political thought, the 6 books of the Republic. It was first published in French in 1576. He included numerous references to More's Utopia. Bodin recounted a decision of the Parliament of Paris and the decision of the 1558 decision of the Parliament of Toulouse. Bodin's book was widely read in England in French and Latin versions, so much so that in 1606 an English translation appeared. In the English version, Bodin wrote, and I quote, "The slaves of strangers, so soon as they set foot within France, become frank and free," close quote. Bodin had earlier referred to the charter that Louis X made in 1315. Bodin refuted the argument that a prisoner of war could, with justice, be made a slave. He wrote that those who lost a war might do so because they were weak, not because their cause was unjust. He attacked the cruelties to which slaves had been made subject. Bodin recounts that it was because Roman jurists considered slavery to be against nature that they found means by which slaves could be set free. If laws or wills or judgments or contracts were unclear or ambiguous, or if there were no law governing a particular situation, the jurists interpreted the law in favor of granting freedom. Similarly, in France, if a formerly enslaved person entered into a contract by which they purported to restrict their liberty to a greater extent than was normal for free people, the contract would be declared void by the courts. In medieval England, freedom for villains was procured by legal arguments and fictions similar to the arguments of the Roman juries described by Baudin. These are early examples of what became known as the principle of legality. There is no record in the 16th century of an English court freeing a slave who came to England. It was early in the 17th century that Europeans of mainly British origin settled in the North American colonies. Soon afterwards, in the southern colonies, they introduced slavery, which was already practiced in the British colonies in the Caribbean. In Virginia and the Caribbean, landowners wanted slaves, mainly for the cultivation of crops such as sugar and cotton. There were insufficient indigenous people, or Europeans, willing to do the back-breaking work. For the same reasons, slavery was also introduced into the French Caribbean colonies. In 1681, Louis XIV formalized the legal status of enslaved people in the French islands. His order of 1685 is known as the Code Noir, or Black Code. This code declared enslaved people to be chattels, the French word was meuble, but unlike any laws in the British colonies, the French code accorded rights to enslaved people. These rights included not to work on Sundays, to be fed, clothed, and housed, even when they were old or sick, and not to be sold separately from their spouses or young children. However, even with these rights, the Code Noir was in clear conflict with the principle of liberty applied in metropolitan France. In 1716 and 1738, further edicts declared that the slave owners could retain certain of their rights over their slaves when they brought them into France. The Code Noir and the edicts of 1716 and 1738 represented so great a derogation from the principle that France was a land of liberty that the Parliament of Paris refused to register these edicts. There was never any statute enacted by Parliament in England to authorize slavery in the colonies, and as I've said, the common law didn't recognize slavery. Slavery was only made lawful in the British colonies by laws enacted in the colonial legislatures. The first such law was in Barbados in 1661. In Virginia, they were consolidated in 1705. These English laws on slavery did not recognize any of the few rights which were accorded to slaves under the French Code. The conflict between the laws of the colonies, which recognized the legal institution of slavery, and the laws of England, which did not recognize it, soon gave rise to disputes in the courts of England. In 1705, there was a case in London concerning the sale of an enslaved person which took place in Virginia. The enslaved person was the subject of the lawsuit in England. He was not one of the parties to it. According to the law report, the judge distinguished between villenage, which was a status which had been recognized in English law, and slavery, which was not. The Chief Justice, Sir John Holt, declared that, and I quote, "As soon as a Negro comes into England, he becomes free," close quote. There was, in fact, no precedent or authority for this statement. It seems likely that Sir John Holt was inspired by the similar statement about France, which Baudin had made and which I have already quoted. If Chief Justice Holt did have regard to French law, this would not have been exceptional. In the previous century, another judge, Sir John Doddridge, explained that the common law copied French civil law as it was taught in Paris at the University of Sorbonne. Doddridge wrote that when the law provided no guide, the French, quote, resort to the laws of nature, which is the ground of all laws, close quote. By law of nature, the he meant what we call human rights. In 1716 in France, there was enacted an edict which sought to establish conditions whereby enslaved people might be retained in France if they were brought there by their masters, as already mentioned. The French courts found means not to enforce it. Between 1730 and 1790, when the Admiralty Court of France was abolished, 247 slaves were freed following petitions for freedom before that court. Of these, 98 were freed before 1770. A notable example was a case in 1738. An enslaved African called Jean Boucaud sued his master, Maître Verdurin, who had brought him into France. The French equivalent of an attorney general made a speech in support of Boucaud. He argued that all men were born free and equal. Then, referring to the decree of 1315, he said that Christianity and the king, and the judges acting in the name of the king, ensured that liberty reigned in France, so that as soon as a slave set foot in France, he gained his liberty. He referred to the case decided in 1558 in Toulouse. He added that all legal authors attest that, as a maxim of French law, Boucaud was freed by the French court. In 1749, Baron de Montesquieu, who was a senior judge in Bordeaux, published his famous work known in English as The Spirit of the Laws, which appeared in English very soon afterwards. He addressed the arguments which Roman lawyers had used to justify slavery, namely, that it was a merciful alternative to killing the defeated. Montesquieu argued that this could not be accepted in a Christian society which accorded higher respect for human life. First, Montesquieu argued that it is false that killing in war is lawful, other than in a case of absolute necessity. When a man has made another his slave, he can't be said to have been under a necessity of taking away his life, since he actually did not take it away. Montesquieu also rejected voluntary slavery. I quote, "Neither is it true that a free man can sell himself. Sale implies a price. Now, when a person sells himself, his whole substance immediately devolves to his master. The master, therefore, in that case, gives nothing, and the slave receives nothing." Close quote. Montesquieu also published a famous satirical work called Persian Letters. One of the targets of his satire was the enslavement of women forced into polygamous marriages and life in a harem. In 1765, William Blackstone in England published the first edition of his commentaries on the laws of England. The first and main editions were in English, but in 1774 there appeared an edition in French as well as in many other languages. Blackstone repeated the words used by Sir John Holt in 1705. And I quote, "A slave or a Negro, the moment he lands in England, falls under the protection of the laws, and with regard to all natural rights becomes eo instante a freeman," close quote. But this statement was still no more than an aspiration. Blackstone qualified the statement in later editions. Unlike in France, enslaved people were not being freed by English judges at that time when Holt and Blackstone were writing. Blackstone repeated the arguments of Montesquieu, refuting the supposed justifications of slavery. In 1769, the leading English abolitionist, Granville Sharp, published a pamphlet setting out the arguments why slavery was unjust and why tolerating it in England would be dangerous. A contemporary French abolitionist was Guillaume Thomas Reynal, a philosopher and priest who is commonly referred to by his title Abbé Reynal. In 1770, he published a major work in which he criticized European colonialism. The chapter on slavery captures his thesis in the short title of the French version, which I translate as, and I quote, "Slavery is repugnant to humanity, to reason, and to justice," close quote. In support of abolition, he invoked human rights and repeated the arguments of John of Salisbury in the words, and I quote, "All men are brethren. They have one common father, an immortal soul, a future state of felicity," close quote. He warned that Africans in the colonies would rebel. In the 18th century in England, the abolitionist movement was initiated by Quakers and soon attracted mass support. The movement invited free African Americans to give lecture tours in England. Such popular support for a political cause was unprecedented in England and unknown in the rest of the world. In 1772, James Somerset was an enslaved African who sought the help of the abolitionists in London. He was held prisoner by Charles Stuart. Stuart claimed to have acquired Somerset as a slave in Jamaica. Stuart brought Somerset to England and detained him with a view to returning him to be sold in the Caribbean. In an application for habeas corpus, Francis Hargrave was one of the counsel for Somerset. He published what lawyers today would call his skeleton argument as a pamphlet. It's actually a book, you see it there. He cited Baudin and the French law I've referred to. Somerset succeeded in obtaining his release from custody by order of Lord Mansfield, but it was only just. Lord Mansfield was very hesitant. In 1778, there was a Scottish case, Knight and Wedderburn, which confirmed that the status of slavery was not recognized in Great Britain. But 4 of the 11 judges dissented. 2 of the judges referred to French law. In 1789, Olaudo Equiano, who lived from 1745 to 1797, published a book about his experience of slavery, arguing that it corrupted the slaveholders as much as the enslaved, and that it infringed human rights, words he himself used. In France, a campaign for the abolition of slavery commenced in 1792, when the prominent French playwright Olympe de Gouges published her play, The Slavery of Blacks. Jacques-Pierre Brissot de Varville was a leading French abolitionist. As remarked above, in 1782, Brissot referred to More's utopia as setting the proper limits to forced labor. The utopians employed as, and he used the word slaves, only prisoners of war whom they'd captured themselves, and that this form of slavery was not hereditary. The number of slaves was small, and utopians made them carry out public works. Brissot also noticed that the third category of people referred to as servi by More, namely economic migrants with work permits, were in a different category. With the encouragement and support of the British abolitionists, in 1788, Brissot founded the abolitionist Société des Amis des Noirs, the Society of Friends of the Blacks. He later became the leader of the Girondin, or moderate party, amongst the revolutionaries. The Marquis de Condorcet was another prominent figure, both in the French abolitionist movement and later in the Revolution. In 1790, he published an abridgment of More's Utopia, drawing attention to the fact that the only, and he used the word esclaves or slaves in Utopia, are criminals, and that is almost the only punishment to which criminals are sentenced. Slavery in the French colonies was not abolished by the Revolution. The Declaration of the Rights of Man and Citizen declared all men to be equal. It formed the preamble of the new French Constitution of 1791, but the Constitution expressly excluded the colonies. This led to the successful revolution of enslaved people in what became Haiti in 1791 and 1804, led by Toussaint Louverture. A decree abolishing slavery in the colonies was made in France in 1794, but it was reversed by Napoleon in 1802. In Britain, the Abolition of the Slave Trade Act of 1807 and the Slavery Abolition Act, 1833, are well known. The 1807 Act prohibited the trade in enslaved people. The 1833 Act set them free if they were within the British colonies or came to Britain. The 1833 Act also prohibited the colonial legislatures from enacting any statute inconsistent with this. Slavery in the French colonies was eventually abolished in 1848. In the USA, abolition was achieved by a civil war. In those parts of the rest of the world which had not been colonized by Britain or France in the 18th century, abolition of legal slavery was largely achieved by peaceful means over the 19th and 20th centuries. Before concluding this lecture, I raise the question, why does the history I have recounted matter today? I suggest two answers. First, it matters to everyone. The 1833 Act abolishing legal slavery in the British colonies is marked by memorials such as the one next to the Houses of Parliament. The disappearance of slavery within Britain itself in the 2 centuries following 1066 is less well known. To the best of my knowledge, there is no memorial or commemoration of it. But that disappearance of legal slavery in France and Britain in the 12th to 13th centuries was a momentous event in the history of the world. It was no less significant than the abolition of slavery which occurred in the 19th and 20th centuries. It, too, deserves to be remembered. One reason why the disappearance of legal slavery in Europe from the 12th century was so important was because it gave rise to the inconsistency between the illegitimacy of slavery in Britain and France, on the one hand, and, on the other hand, its legitimacy in their colonies. This inconsistency was a major reason why legal slavery ultimately did not survive all around the world. The history I've recounted also matters, in particular, to lawyers. As I've sought to demonstrate, the disappearance of legal slavery in France and Britain and the corresponding recognition of the right to equality was justified by arguments which had been advanced since the 12th century. In the following centuries, most notably in the late 18th century, lawyers and campaigners in Britain and France continued to influence each other in advancing abolitionist arguments. The anti-slavery statements of Chief Justice Holt and Sir William Blackstone, which became famous in England, and the landmark decisions in England of Somerset's case and Knight and Wedderburn in Scotland, followed the citation in court of French law dating from the 15th and 16th centuries. In modern times, leading human rights texts, such as the Universal Declaration of Human Rights and the European Convention on Human Rights, are, in large measure, the fruit of a dialogue between French and British lawyers. Today, British lawyers and judges commonly take into account jurisprudence from international human rights courts and from the national courts of other English-speaking countries, but rarely from our nearest neighbour. Before the 19th century, there was no Australian or Canadian case law. Our lawyers and judges looked to the case law of European national courts, mainly from France. I would question whether there was ever more important case law cited in British courts than the French law on slavery, as explained by Jean Bodin, which inspired Chief Justice Holt in 1705 and was cited by Francis Hargrave in 1772. Thank you.
Thank you very much. I need to just switch on. Thank you so much, Michael, for that. I hope we'll take a few questions that we have. I have one online, and no doubt so there will be others from the audience here. There's a microphone. When you have the microphone, would you be so kind as to use it I know many of you have strong and powerful voices which would normally travel in the room, but in order that we can record it properly, because this will be recorded online, it's necessary to have the microphone near you at the time. So please use the microphone when it's your turn to speak. Well, shall we start with any questions in the room? Yes. Professor Michael Loban.
Thank you. In the worst possible position for the microphone. Thank you very much. That was a fascinating talk. I was thinking about particularly in the 18th century, how the judges, while you have the comments that you mentioned about the liberty, Holt saying, let the Negro go free, they're also recognizing property in slaves by upholding property claims where, again, the slave is not present. They're on the other side of the Atlantic. But I wonder if there's a tension between views of liberty and property that judges have to contend with, if there's something worth saying about that.
Yes, of course there is and was. That was one of the major problems which were faced by the abolitionists. The slaveholders maintained that the slaves were their property. Property was a right which was given perhaps disproportionate respect over much of the period about which I've been talking. It figures, of course, in the French Declaration of the Rights of Man, as it figures very largely in American declarations in the States and elsewhere. The obvious issue was whether a human being could be the property of another human being. But the abolitionists at first tended to try and avoid taking on the slave owners on the issue of property, which is why the first statute to be passed in England was the abolition of the slave trade, which didn't involve an assault on property. It had been thought that that would lead to the dying out of slavery. If the trade didn't continue, the existing slaves would die and they wouldn't be replaced. But that isn't what happened. And that's why in 1833, the Abolition Act was passed. As many of you will know, it was passed at immense cost. 20 million pounds of compensation was paid to the supposed property of the slave owners, nothing at all to the slaves themselves. And the United Kingdom was unique in that respect. France, one of the reasons they didn't abolish slavery in the revolution is they couldn't afford to. The revolution occurred because France was effectively bankrupt, and the slave owners demanded compensation, and they were a very strong lobby. And that was one of the reasons why the obvious remedy of freeing the slaves didn't take place in the revolution. Thank you.
I have a question here from Christopher Curry. It says this: given that following the work of John Gillingham and other historians generally regards slavery as having disappeared in France during the 11th century and in England before Stephen's reign, do you think that the philosophers' and lawyers' comments, however influential later, were lagging behind the facts on the ground?
The answer is we don't know. Not everything survives from that period, and it may very well be that the disappearance was unconnected with what the philosophers and lawyers were saying. That is certainly an argument that is made. What is striking, though, is that slavery had, in other parts of the world, for one reason or another, disappeared temporarily from time to time. Slavery was often used as a means of displaying status, for example, and powerful monarchs who disapproved of the excessive claims to status of some of their powerful subjects, would deal with it by liberating the slaves. But what is striking about the events in Europe that I've been describing is that the disappearance was permanent, and there was pressure to reinstate it. If the decisions in 1772 had been made, had been different, the lawyers who were representing Somerset, for example, pointed out that there were slaves in Russia and all over the Eastern Mediterranean and much of Eastern Europe, and if the detention of Somerset was to be upheld, the same would apply to slaves coming into Britain from all sorts of places. There would have been an increase in the number of slaves who had already existed in England, people who had been enslaved elsewhere, not enslaved in England, but who had been brought or had come to England. So yes, it is unclear, as I stated, why the legal status of slavery disappeared in Europe. We're not even sure that it did actually disappear as a legal status until the lawyers and philosophers were talking. What disappeared was the condition of slavery, or disappeared up to a point, of course. It was never eradicated, and it hasn't been eradicated today.
I'll come to Patrick in a moment.
Michael Darcy. I wonder, would you like to comment on what difference, if any, the French Revolution made in the eradication of slavery? I'm conscious that in the 12th and 13th century, a lot of the philosophy driving the elimination in England and France would have been Christian. So what difference, if any, did the French Revolution make?
Well, the French Revolution wasn't a Christian revolution, but a very large proportion of those who drafted the 1791 French Constitution and the Declaration of the Rights of Man were clergy, not necessarily very well-behaved clergy, but many of them were. Some of them were very sincere, like the Abbé Gregoire, and others were not. The French Revolution, insofar as it reflected Enlightenment ideas, is rather ambiguous. One of the less attractive features of the Enlightenment was that it gave rise to questioning whether all mankind really were one race. That question arose because of the increasing discovery of indigenous populations who appeared to be both physically and in their habits very different from Europeans. And so the Enlightenment, to that extent, weakened the force of the story of Adam and Eve. Although many Enlightenment philosophers, including Tom Paine, who were not Christians, continued to assert Adam and Eve was a historical story. So in that sense, it didn't really make any difference whether they were Christians or not. The other impact of the French Revolution, sadly, was probably to defer the delegalization of slavery because of the inability of the French to compensate the slave owners, and because of the association of Napoleon through his wife with Caribbean slavery and many other factors as well.
I have take another question online and then come to one from the room. This is from David McIlroy. Would Sir Michael like to comment on the influence of John Locke, who both drafted the Constitution of the Carolinas, which permitted its proprietors to own slaves, and was paid by Charles II in stock in the Africa Company? He also defended slavery being imposed on prisoners of war.
Locke is a troublesome figure. He is a hero of liberal thought, and the facts you recount are unquestionable. They're as clear as day in his writings. I didn't mention him because he's such an ambiguous figure. And he starts his first treatise on government with a paean to liberty. But it turns out what he's actually referring to is what was commonly called at the time political slavery. That is the slavery of anybody who doesn't have the right to vote. Now, I think I would like to say a word in defense of Locke, which is that the arguments which he puts forward for slavery, for the most part, seem to me to be directed to what is not slavery, namely the imposition of forced labor or penal servitude on convicts. And at the time that he was writing, he might well have thought that most of the people going across the Atlantic were convicts of one kind or another, or otherwise blameworthy. That may be too kind to Locke, but if I'm not mistaken, he doesn't put forward a reasoned argument in support of slavery in the sense of taking people from their homeland who have done nothing wrong and not even waged a war, and transporting them across the Atlantic. I don't believe he actually puts forward a justification of that, but of course, as the questioner rightly points out, that was a significant proportion of the people who were in South Carolina.
Patrick O'Connor, KC.
Thank you for your lecture, wonderful. Is it right that when the French government gave independence to Haiti, they insisted on a provision in the treaty which gave to the French government a certain proportion of the independent Haitian gross national product or budget, however it was measured, and that these payments continued into the 1950s? Now, I've read that somewhere. It
is true.
Now, if that's right,
yes.
French thinkers come out of your lecture glowing with merit, but perhaps French governments over quite a long time don't come out so well, do they?
The French come out well from what I've said in terms of the legal thinkers. They don't come out better in terms of the way they behaved in the Caribbean. The Code Noir is better than anything any English-speaking people produced. Doesn't mean that it was enforced properly. And what you describe about Haiti, indeed, the very fact that they attempted to suppress the revolution in Haiti with such huge loss of life, in which, I might add, I'm afraid to say, they were aided by the British, it reflects very badly on all of us. I don't mean what I said tonight to be an unqualified paean of praise, whether to the French or to the British, but I do mean it to give such merit, such credit as is due. Thank you.
A question from an online question from an anonymous cynic. Could you comment on the argument that slavery in England largely disappeared during the 11th century because of the introduction of feudalism? Serfs owed labour to their lords, and the feudal lord was not required to feed and clothe the serfs. Slaves had to be looked after, so it was economically better to have serfs than slaves.
Well, there's much force in that, and the same might be said of the 1315 edict of King Louis X. It is cited as foreshadowing 18th century thought, but the difficulty about it is that what the edict envisaged was that the serfs would buy their freedom. So the the glowing words with which it begins are not really followed through. That is part of the history. It's a mixed history.
Thank you. Back, please. Thank you.
Very much. Hi, my name is Anna. Hi. I was just wondering how we can account for the retention of feudalism in sort of small areas in the Channel Islands. I'm aware that in 2008 there was a case before the European Court of Human Rights about the Channel Island of Sark. And in the context of all of this happening, especially between France and Britain, how did this small landmass in between get left behind?
Well, if there were slaves in the Channel Islands recently, I didn't know that. And I'm very sorry to hear it, all the more so as I used to be a judge there. I certainly didn't come across it. It's a mystery why the French never took over mystery to me why the French never took over the Channel Islands. They were indefensible and could have been taken over on many occasions, but the French didn't do it. And they are the last surviving relics of the Duchy of Normandy. And they're therefore not a part of the United Kingdom.
I don't think I have no more questions online, and we seem to have exhausted the questions in the theatre. So, Michael, thank you so much for such an enormously scholarly and interesting discussion. We're very privileged to have heard from you this evening. Thank you.
Thank you.